Hi, everybody. Welcome to Releveraged, conversations with founders building interesting businesses in the legal sector. Each episode explores how lawyers and legal entrepreneurs are creating value and servicing clients in completely new ways, with a focus on the commercial realities of what they're building. Today's guest is Philip Young. Philip spent 25 years as a commercial litigator and in 2022 started building Garfield, the first SRA-regulated law firm in England and Wales and across the UK that runs on artificial intelligence. And it helps organisations to recover debts of less than £10,000 through the small claims court. In the last 12 months, he's been on Channel 4 dispatches, Bloomberg Law, Forbes, The Economist, The Times, more mainstream press than almost any other UK legal tech founder that I know, certainly in my recent memory. Philip, thank you for joining us. Welcome to Releveraged. Really excited to welcome you as our first guest.
Thank you very much, Alex, and thank you for that very kind introduction. I appreciate it.
Great, thank you. So before we get into it, I've got a question for you.
Okay.
Are you an AI bull or AI bear?
I think I would go for AI bull because I think that AI is absolutely transformational for law and legal services, and probably for very many other professions and markets as well, though I obviously haven't focused on them as much as I have done on my own.
Excellent. I thought you might say that given the nature of what you do. So great. Let's hear a bit more about Garfield. You launched in 2022, have I got that right?
Well, we started building it in 2023. I think 2022 was when ChatGPT 3.5 came out, and then that was when in sort of October, November time, and that was when I first had the sort of realization in playing with it that this technology was going to be transformational. But it actually didn't occur to me that I was going to do anything with that until 2023 when ChatGPT 4 came out, and then I thought, gosh, well, maybe I could build something with obviously other people.
Okay.
And in terms of when we actually launched the product, it was really when we were regulated, which was March last year. Though we were going to do a stealth launch for the first year, but we were then unstealthed, if that is a word, in May by the Financial Times discovering us and then writing about us. So that's been our story so far, so to speak.
Okay, amazing. I actually wrote about you around about that time as well, and I think it's still the most engaged piece of content that I've ever put out on LinkedIn. So it just goes to show that there's huge interest in what you've done and what you're continuing to do. And you have got immense publicity and coverage, so congratulations on that. I personally have been singing your praises to anyone that will listen, really, about the model that you've developed and the customer experience that you've created. But can you tell us a little bit more about the business and actually what it does?
Yeah, sure. And well, thank you very much, Alex. I mean, all publicity is good publicity, as they say, and I appreciate you saying nice things about us. So what is Garfield? Garfield is essentially a software application that does everything that a traditional law firm would do for a client in pursuing a small debt claim through the English and Welsh courts. It is regulated in exactly the same way as any other English and Welsh law firm. The difference fundamentally is that instead of providing a service by humans, it provides a service powered by software and AI. It's a lot faster than humans, inevitably, and arguably it's a lot more convenient because it's available 24/7, whereas, of course, for a lawyer, you've got to make an appointment and then talk to them when they're available. And it's also a lot cheaper. Inevitably, because it's a software product, we don't have to worry about human costs, and so we're able to price it in a very different way. It's no secret that the debt product is the first of many products, which we're going to be rolling out a whole series of further products in the course of the next few months. Because we've always said we built Garfield in a modular way, and the idea is that it's a platform, and so people with other sorts of claims will be able to drop into Garfield, and Garfield will help them in exactly the same way that it helps people with small debts. I should say that in terms of small debts, we already cover the entire range of businesses in England and Wales. So we have everyone from sole traders all the way up to, as of the last month, a regulator. Not the
Okay.
SRA, but I won't say who. And that's amazing to have the credibility of a regulator on the platform. And a surprise to me, because you think regulated individuals would pay their debts to their regulator, but apparently not all the time. And also a giant utility, and some other companies as well that are very big are coming on the platform. So we're seeing our original thesis that there would be a demand across the whole business spectrum being proven. And so what we're now doing is moving from a sort of the early stage into the next stage of our evolution, which is a scaling stage. And we've just taken on our first salesperson, and we're starting to do outbound conferences and outbound marketing. So we're a sort of interesting inflection point where we're now going to be beginning to grow quite a lot.
Okay, amazing. I'm very excited to hear more about what you're going to be doing moving forwards. And I've got a couple of questions for you on that later on. But can we go back to right where this all began? Like, how did you get started? What did the first 6 months look like for you? And I think, for me, the beginning isn't necessarily when you incorporate your company. It's when your thinking around the business starts to crystallize. So what did that first 6 months look like from that point?
Yeah, so this was 2023. So basically ChatGPT 4 came out. I thought this is a really big jump in capability, and now it's possible to build something useful with this. And then I knew what I wanted to build. I wanted to build something that would help my brother-in-law, Andy the plumber, who I've spoken about elsewhere, and businesses, other businesses that have small debt claims. So I knew what I wanted to do. And I also knew that I wanted to do it in a modular way so that we could expand it to other claims in the future. But I wanted to start with debts. And then what I thought to myself was, okay, I am a nerd. I can code. It's not my sort of core skill set. So although as I'm talking to you at the moment, I'm very conscious that on my left out of camera shot, I have a huge wall of programming books. And there's some more recent than others, because some are sort of Python and God help me, TypeScript. Not a fan of TypeScript. But some are sort of older languages like C and C++ from when I was much younger. So that's sort of one of my hobbies. And so I knew I could do some coding, but I also knew that my skills were not extensive enough that I could build the product by myself. So I knew I needed a co-founder and somebody more technical than me. So I went out and looked for somebody, and I found Dan. And essentially the way I did that is I beauty paraded people. It's that phrase that solicitors like me use when we refer to instructing barristers in traditional litigation or experts, people like that. I went off and I found people that had what I thought were the right skill sets, a passion for doing something like this. And of all the people I met, Dan was absolutely clearly the standout guy. We just got on really well. And I think with any sort of new business, you need the founder, whether they be partners in a law firm or shareholders in a traditional company or founders in a tech company. You've got to have a really good personal relationship between the founders. I always think it's a bit like a commercial marriage.
Yes.
Don't know if Dan would appreciate that description of our relationship, but you know what I mean. Yeah, and he's such a clever chap, and he got it, and he was passionate about the project, and so between the two of us, we started building a prototype. And although I've spoken about Python and TypeScript, and that sort of tells you that the front end is built in React, we actually started it off with Flutter, because we started by thinking, it would probably be a mobile app. And so we built some of the back end in Python, and then did a lot of the front end in Flutter. And I actually really like Flutter, and I particularly like the language that it uses, Dart. I think Dart's a very elegant programming language, but it became apparent to us pretty quickly that this was really a desktop laptop product, not a mobile product. So we decided not to bother with Flutter going forward and switched to React.
And what told you that you should make that switch?
So basically, trying to look at PDFs on a mobile phone. Because essentially, any sort of product that is law related is document powered, document heavy, and we just thought, well, okay, you can look at PDFs on a phone and you can sort of turn the phone sideways and all of that to read it, but it's quite painful.
Yep.
So although Garfield is mobile ready and works on mobile and has its own mobile application, in fact, it's really fundamentally a desktop and laptop product so that you can see the documents and do the dialogue with Garfield effectively. So then what we did is we realized we needed more help on the front end because Dan is a full stack guy, but he's probably more back end than full stack. And so we went off and found Pablo, who Dan knew, because I've always believed that if you're recruiting is fundamental to any business. You've got to find the right people. And it's so much easier if people already known quantities. You're not taking such a big risk. And so Dan had worked with Pablo at a different startup before. And so Pablo came on board. And then that was probably the first 6 months. And then later on, of course, we expanded the team more. And then we moved to a world where we also obtained some external funding to expand the team and progress.
Okay, excellent. And I mean, you talked a lot there about the product side. How much commercial thinking did you do before getting into the weeds of building an actual application? Did you go out and do some customer research beyond speaking to your brother-in-law? And how big do you think this market is? Did you look at that before you started building?
Yeah, I mean, you've got to do that. I think there's no point building a product if no one's going to use the product, or if you're building something that either there's no market for, or you're building the wrong sort of product. So there is a demand, but you're not hitting the demand. You've also got to think a bit about pricing and stuff like that. So I knew from my days as a practicing lawyer that there are plenty of debt claims, and I did a bit of research, and the Ministry of Justice publishes statistics quarterly on county court claim issuance. And so I could see from that there are on average about 1.7 million debt claims, small debt claims issued a year. So that gave me an idea of the existing market. I was also very conscious that from my time in practice that the overwhelming majority of small debt claims are not pursued at all, because using lawyers is just uneconomic and too time intensive. And doing it yourself is just too time intensive and daunting for a lot of businesses. So I knew that the total addressable market would be many, many times the current issuance. And actually, when I look at what we are experiencing, I think from talking to some of our users that it's anywhere between 5 to 10 to more times than that, because we're seeing people that say, "Oh, I might have issued one claim form and I'm issuing 10 or 15." So I knew that if done right, the technology would open up a market that at the moment is very inefficient. And then I also did a bit of research on the total size of what you might call the debt market, the unpaid debt market in England and Wales. And there's many different statistics out there, many different surveys. The biggest figure I've seen was a survey done by Hiscox, the insurance company, and they said £70 billion a year, which is a huge, huge figure. The Small Business Commissioner did a survey just solely aimed at small businesses, and she came up with a figure of, I think, about £26 billion a year. I've seen figures of sort of £6.5 billion. So there's many different figures. What is very clear is that it is a huge market, and it's what you'd expect, because anyone who's been in business knows that every week or month, depending on how often they do it, there has to be people sat down and look at an age debtors report, and the age debtors report has always got lots of age debtors on it that people would prefer to be cash rather than unpaid invoices. So I knew however you decided to try and analyze it, it was an enormous market, and it was very inefficient and ripe for some improvement.
Amazing. And what I really love about what you've done is you've in essence created a new market that previously wasn't being serviced, if I've understood you correctly.
Yeah, we think we have.
Yeah, that's really exciting. And on that note, who is your ideal client? From what I understand, you have a couple of different service tiers as part of the Garfield offering. So how do you think about the different ideal client profiles, if you like, and how are you tapping into each part of those different market segments?
So I mean, in it, we're not a very narrow product. We're broad because as long as you've got a debt up to £10,000 and your debtor is in England and Wales, you can use Garfield. So therefore, pretty much any professional or industry vertical can use Garfield. I've not come across any that can't so far. And so we've got a very broad market and a very broad sort of ICP. In terms of where our heart is, obviously our heart is the smaller end of the business spectrum. So we're thinking about the Andys, who are the plumbers of this world, because we started building something to help them. But the economics of the business are, of course, in the big companies with a large volume of debts and a large volume of claims, because you need volume to support this sort of business model. And so we have sort of different routes to market. And for the larger volume users, it's a traditional sort of route with sales people and going out to conferences where they're going to be at and things like that. That's what we've decided we're going to do with those sorts of people. Obviously, because we have hit this inflection point where we're about to start scaling, we've been just dealing with inbound so far. And so quite a lot of big companies have found us just from all the press interest and the marketing we've been doing. But that's sort of brand marketing. It's not sort of focused outreach marketing. So yeah, very much on the bigger companies, it's traditional routes. And then smaller companies, very much things like Google brand advertising and getting known in the right circles with influencers and people like that. That's very much our approach. And from time to time, of course, we do a bit of, old-fashioned sort of SEO, and we'll probably do more of that as time goes on. But that needs to be quite focused, I think, to reach the right sets of eyes.
Excellent. Would you mind sharing a little bit more about your commercial model? And I think from what I looked at previously, that your letter before action in terms of like the first step in this process is just £7.50 on Garfield. So how are you able to operate at such a low price point? And without asking you to open the books, can you give us a sense of what the unit economics might look like?
Yeah, so our economic model is, at the moment at least, it sort of follows what the court allows recovery of. So for letters for action, we charge £7.50, obviously plus VAT, and there's also an optional postage charge as well if the user wants Garfield to hard copy post the letter for them, which most users do, because it's so much more convenient for them than them having to sort of download it and print it and post it themselves. And with LBAs, the pre-action protocol says that you have to post those. So someone has to post them. So it's easy to get Garfield to do it. And then for later stages of for the court process, we charge per stage, and we charge a fee that is at or below the sum of money the court allows recovery of for those stages where there's a recoverable fee. So, for example, for a small claim of I think it's £5,000 to £10,000. From memory, the court allows recovery of £100, so we charge £100 for that. So from our perspective, the economic model is both in volume and also primarily from court claims, because as you go through different stages of a court claim, you can charge different fees. So if you issue a claim form, then apply for default judgment, for the default judgment, you can from memory, the fees are either £22 or £30, depending on how big the claim is. And of course, that's recoverable from the debtor as well. At some point, we will offer subscriptions as an option, I'm sure. But we need enough data on the platform to be able to price that effectively in a way that people would use. And obviously, as we expand the product offering, then there are more things that users can, if they want, do and pay for. So that's the current economic model. So it's very much a sort of volume model.
Yeah, I hear you. And are you still involved in reviewing every single output that the system produces?
Less so. So some of our processes do not involve any form of probabilistic LLM process. So for those, they are deterministic, and it's not necessary for me to review documents that come out of those anymore. I do, because I'm like all lawyers, I'm little bit OCD. When I say a little bit, I mean very much OCD. And so I do sort of sample those and drop in and drop out. But for the probabilistic documents, I'm still checking those. The volume is not such that that's difficult or impossible. And we've also built and are constantly improving an AI overseer itself that I've also been keeping an eye on to make sure of its accuracy, so that in due course we will have that as a first level review solely, and then we'll only escalate to humans when that thinks something needs to be looked at by humans. It is an interesting process, this, because as I've been sort of jovially saying in other places, I can see the point in time is rapidly approaching where the human in the loop will be a risk rather than a benefit. And I give as an example something that happened last month where I looked at a document that Garfield had produced. I thought, where does that fact come from? I don't remember seeing that fact. And I went back through the claim and had a look. And what Garfield had done is it spotted a footnote in a document the user had uploaded. And the footnote was in a very tiny font size. But of course, to an AI, it doesn't matter if it's font size 6 or font size 40. It's exactly the same text. And then Garfield had found an important fact buried in this font and pulled it out and applied it. And I, as a human, probably would have missed that. I probably would not have spotted the importance of the tiny footnote. And I just thought to myself, crikey, this is a demonstration of when we will get to a point where technology is more reliable than humans, and then the humans in the loop will be a negative rather than a positive.
Yeah, I hear you. I couldn't agree more. And you've obviously got a very close relationship with the SRA. What is their view on that? Is there a point in time at which you can remain a member of the SRA and regulated, but actually not have a human in the loop? Is there a certain threshold in terms of accuracy that they might be looking for? And I think this is a question that's on a lot of people's minds, right? It's like, at what point does the human in the loop no longer become a mandatory component of delivering this service?
Yeah, so I mean, we've been meeting with the SRA every quarter since we were initially authorised. Now, originally, they preferred to meet every half year, but we proposed every quarter because we thought that would be more useful to them and also to us. And they agreed, and they've been very interesting meetings. We've had a very very candid sort of discussion every time about what's happening in the market, what's happening with Garfield, what we're seeing, and we've been trying to pass back know-how as well, because we are the guinea pig for the SRA on this, and arguably the guinea pig for the legal community globally, given that we're the first people to be doing litigation using AI in a regulated way. So we've been very conscious that we owe a sort of citizen's duty to try to help the regulator sort of prepare for this new world. And also, to a slightly lesser extent, we've been talking to the Legal Services Board, the legal super regulator, who are also very interested, and also parts of the government. So in terms of the SRA's view, as I understand it, of the future, they've always been willing, in principle, to accept the idea of not having to check every document. So very much, as long as what's going on is clearly prudent and appropriate in accordance with the regulatory rules and also your duties to the court, then they've been comfortable, in principle, with the idea of that. I've not yet reached a point where I want to move to a purely sampling approach for things that involve LLMs. And that's again because I'm like all lawyers, I'm very cautious and very OCD, and I'm probably a bit difficult. I probably struggle personally to let go, but I will eventually. And also, it's just so interesting reading what Garfield produces and how it's produced it. I mean, so you have these, even though it's a product I've been working on for 3 years now. I still have every week one or two crikey moments where I look at something and think that's so good. Like last couple of weeks ago, Garfield did a set of witness statements, and they were just, I mean, I read them and I thought I changed like one sentence in 4 witness statements, and that was it. And I only did that because I felt I should do something. That's how good they were.
Amazing.
It's amazing. And Yeah. So the other aspect of this that's obviously also been relevant has been the Mazur case, and what that might have meant. And actually, I think that has opened up, or at least not created a blockage for sort of sampling as an approach, because the Court of Appeal was really clear that it's fundamentally a question of supervision. And as long as you've got regulated, authorized people doing an appropriate level of supervision the regulator's happy with, then that's sufficient. So I think that's also helpful too, because it means there's not some sort of difficulty created by the regulatory rules. And I,
Okay.
and so I think that's where we are. We're going to end up in a world where I mean, I'm still responsible for everything. I'm accountable. I am the culp of the law firm, and I think the SRA would expect that. You know, they're not going to allow a regulated service to be provided without all of the accountability and responsibility that comes with that.
And if you had to put a timeline on it today,
Oh, okay, go on then. But this is going to be tricky, Alex.
yeah, at what point do you think it will be possible for you to extract yourself from being involved in the process?
I reckon in the next 6 months. I mean, I'm moving more towards a sampling approach and focusing on particularly higher risk areas, which really means claims that have got defences and are being defended in court. But that said, I think the question of when I could is slightly different from when I will, just because, as I say, I'm a little bit too hands on, and it's all just too darned interesting, Alex. Yeah. I mean, I think sometime in that period, I would be very much beginning to reduce my checking. I'd also want to talk to the SRA in advance and make sure that they're comfortable with what was being planned. That would be important for me as well, because they're on this journey too, and I don't want to do anything that causes anyone any sort of angst.
Amazing. What so just change tact here a little bit, and we were talking earlier about some of your plans to expand the business, new service offerings, etc., new parts of the market. What is your ultimate goal here? Like how big can this thing be? And I think you've been quite vocal before about the fact that you didn't think that this was you were skeptical about whether or not Garfield was a VC backable business. I think that was well, when we first met, you were talking about that, but you publicly talked about it on the Non-Billables podcast in May of last year. Has your thinking changed on that since then?
So yeah, I mean, this has always been a business that VCs could back, and God knows I've spent a year of my life trying to field VCs trying to talk to me of all shapes and sizes and from all sorts of different countries.
I think a few people would say that that's a good problem to have in some respects.
Well, yeah, maybe, yeah. If you want VC money, it is a good problem
Indeed.
to have. Yeah, I mean, we've taken the approach to date that we haven't sought VC money. We've got a group of angel investors who are brilliant, and they've not just sort of supported us financially, but even more importantly, they've supported us with expertise and know-how and wisdom, and generally being just helpful people to have around. And they've all got a very different sets of skills. And I did pick them. They're all friends of mine, but I also picked them because I knew they'd all be bringing something very different to the table that would also help the business and help get it to where it will need to go. And that said, I mean, I can see that VC money, if from the right VCs who understand the access to justice side of the mission, could be potentially very useful in terms of accelerating, growth and moving into other markets and things. So yes, it's possible. It's possible that VC money will happen, but depends a bit upon who they are and what they want to achieve and how aligned they are with what we're up to.
Indeed.
I mean, I do watch. I mean, I watch Legora and Harvey with a certain amount of wry amusement. I think Max and Winston and Gabe have done a brilliant job in what they're doing, but I also sort of feel for them because the amount of money they've raised, the expectations on them as founders must be astronomical. I'm not sure I'm not sure I want astronomical expectations on me. Moderate expectations might be fine, but not $11 billion or whatever expectation.
Indeed, yeah, it's certainly a lot of pressure and a lot of thinking that might need to be done in order to achieve, and a lot of the work that will need to be done in order to achieve that valuation. So I appreciate your considered approach about when was the right time to take some money. And
Yeah, considered
I
as
think
well.
the other
Yeah, very good word. That I try to be considered.
in terms of where you're taking this and where you're going with this, you've mentioned some new markets, you've mentioned some new products. What can you share about what's coming in the next 6 months?
Well, I mean, I can say a few things because a few things have been said sort of semi-publicly, so I can talk a bit about that. So, I mean, from our perspective, we are now aiming at completing essentially the automation of the small claims track, and we are on the edge of having completely automated that. So we're about to roll out some functionality that deals with enforcement of judgments, and we're also going to do some other types of small debt claims. So at the moment, we don't handle landlord and tenant, for example, but that's coming very, very soon. And then we've got other sorts of claims that are not debt claims that are on the way as well. And then once we've finished with small claims, I think we'll look closely at doing fast track claims. So debt claims from £10,000 to £25,000. Once you can do witness statements effectively, there's absolutely no reason why you can't do fast track. And so we will look at those and then build accordingly. It's since day one we have been thinking not just one thing. We've been thinking further ahead and how else we can build things to help people. And essentially, the fundamental thinking is always, where is there an access to justice gap? Where is there a problem here? Where is it that companies cannot, and individuals are very important too, cannot effectively get legal representation? And what could we therefore do to solve that?
Yeah, and I love that word problem as well. I think it gets bypassed quite quickly when some people get excited about the solution, particularly with everything that we've seen come through with vibe coding and all the applications that you can now use to create software and prototypes very, very quickly, which is hugely addictive. If you've ever used those tools as a non-software developer, in terms of somebody that doesn't have those capabilities. But what I think it amplifies is the lack of due diligence that gets done on the commercial viability of a venture. If you're building something to turn this into a business, really everything is embedded in where is there a problem and how much value can we create by solving it?
Yes,
and you're
absolutely.
evidently doing it that for a section of the market that clearly needed some help because the alternatives weren't fit for purpose.
And you can see that too in the number of people that are trying to use ChatGPT to work their way through a court process, whatever it might be, whether it be in civil or family or crime. And that just shows you that there's a problem because you want to be able to provide regulated products to take people through basically a regulated process. And I agree with you. I think anyone who's thinking about founding a business or starting a business, they should start with what is a problem I'm trying to solve and be passionate about wanting to solve it, because anyone can identify a problem, but you will have your own problems as you build the business, and there'll be those times when you're up at 2 a.m. trying to deal with something that's knotty and difficult and not very exciting, frankly. Those sort of problems are never very exciting. And then you'd be like, why am I doing this? And you need to be passionate about what you're doing in order to get through those sorts of times.
Yes.
And on the vibe coding front, I mean, I've loved that. I've loved watching all these lawyers discovering coding and using Claude Code. And I think it's great. I mean, fair play to them all. Obviously, what I have gently said to some of them who've talked to me about this is it's one thing to build a prototype. It's another thing to have something that's production ready, particularly in a regulated field, and be a little bit careful about that. And that's basically the same advice that a lawyer would give to somebody who is, I don't know, gone off and asked ChatGPT to draft them a contract. It's one thing to do a prototype; it's another thing to have a properly solid thing that survives careful scrutiny. So
completely.
yeah.
And I think this, I think about that whole problem piece in a slightly different way. I gravitate naturally straight to the business end of the spectrum, which is, if we can solve this problem, how much value do we recreate, and therefore how much can we charge, and
Yes.
how much of this problem exists within the marketplace in which we want to operate. You're clearly starting to expand into some, closely adjacent areas. But do you think your model, this way of working, can be applied into completely different areas of legal services? And how far up the complexity spectrum do you think it's possible to go with this approach?
I don't see any reason why it can't be applied in other sectors, because what we are doing conceptually is, it's not. Let me approach it a different way. If you can provide a solution that takes someone through a litigation type process, there are many such processes that may be litigation and might not be litigation that are conceptually similar, where the parties have to explain what the issues are. There has to be production of evidence that relates to those issues, and then someone else, which in litigation context we call a judge, has to decide who's right and who's wrong. So conceptually, that process applies to many things. And if you can build it for one type of process, and there's no reason if you've done the construction in a modular way, you can't adapt it. And actually, to that note, we've been approached by various sort of government departments who have situations where they have basically conceptually similar problems. In other words, they have a large volume of things that are contentious in nature, that are relatively small value, that at the moment they try and deal with basically by humans at considerable cost. And they're then looking at things like Garfield and saying, well, you could build something for us that would dramatically accelerate all of this. And my answer to that is yes, we can. Absolutely, we can. And there's plenty of advantages for them then in exploring that, and also obviously for us in helping them explore it. So that's an example of sort of how you can adapt this sort of technology to things that are analogous to litigation but aren't. And then separately, to your point about complexity, so I think this is limited to an extent by the capability of the existing technology, and it's limited partly by the abilities of the founding team to build a product that can match the level of challenge required. I think those are the two fundamental issues. I've always described civil and commercial litigation, the complexity, as being a sort of S-curve like that, because small claims are, in comparative terms, reasonably simple. Fast track claims more complicated, and intermediate obviously a lot more complicated, and ditto multi-track. But when you get to very, very big claims, like the sort of claims that I used to do when I was in practice, actually the complexity then begins to flatten out again, because if you're doing claims for hundreds of millions and billions, then they're about as complicated as other claims for hundreds of millions and billions. So yeah, and I don't think at the moment that the existing technology could pursue a multi-track claim, for example. I definitely think it could now do fast track, and I think with the right structure and architecture, and also with a bit of technological development over the next year or so, I think we might be able to get to a world where it could start to do intermediate track cases very effectively. You may see a world where you need to have a lawyer on top of the technology for some time, but over time, I think that will drop off. So yeah, that's where I am sort of in my head now, which is different from where I was a year ago, because obviously things have moved on a lot in a year, and goodness knows what will happen in another year's time. Sometimes I look on social media and the internet and things, and I see sort of people doing charts of the current progress in LLM models and stuff, and some look like that, and some look like this. And obviously, the chart looks like that. Well, I mean, it goes exponential. It comes to a point where none of us are doing anything because we're all sitting around eating grapes because the computers are doing everything for us. And I'm a bit skeptical we'll get to that sort of an Ian M. Banks sort of culture world in which minds do all the work and humans just sort of do cultural things. Yeah.
Yeah, indeed, indeed. I think I share your level of the AI bull bear spectrum. I'm quite bullish on it, but I'm not yet at the point where I can see a world, certainly in the next couple of years, where anyone that's doing a desk job in front of a computer is removed from the situation. But I might be completely wrong. Things are moving very, very quickly.
Yeah, I'm like you. I also think there's always. I think what will happen is there'll just be different jobs. Jobs will just evolve, and rather like in the Industrial Revolution, the invention of what was it called, the spinning jenny or whatever it was, that made the production of certain products far quicker and far more efficient. Just meant you had less people actually sitting around sewing. I think it's similar for professional services. We're going to be spending a lot less time doing boring, repetitive grunt work. And also, a lot of advisory work is repetitive too. I mean, I was very conscious of that in practice, and even more conscious at Garfield that a lot of the standard recommendations you give at particular stages aren't just standard. To explain, you've got to produce your documents, so you want to produce someone sort of that are in the small claims track, the ones that are helpful to you, because there isn't the extensive rules on disclosure there is at the higher tracks. That's just the same recommendation every single case. There's no real reason why someone should bill an hour of their time to give that same recommendation to just a new client.
Yeah, I hear you. Philip, we're coming up to time. Can I ask you, what would you say to someone that's been thinking about embarking on a similar journey? Perhaps they're a lawyer in the traditional sense. They've been inspired by what you've shared here today, or they've been following you or what you've been doing over the last couple of years. What would you say to that person?
Go for it, basically. If they are passionate about what they want to do, and this is what they want to do, and they want to build something, and what they want to build is worthwhile, then we only get one life, and there's no point looking back years later with regret because you didn't try. Obviously, people should be responsible, and if they've got obligations such as a mortgage and things, they need to work all that out, how they're going to sort of meet those responsibilities. But no, I encourage people to do entrepreneurial and interesting things. I think that's very important, not just for themselves, but also for the economy and for the country. And, if they build something that helps in a really big way, arguably even the species, which would be pretty huge. Don't know how many people manage that, but, so no, I'm very much for it. I think law as a profession has generally been seen as not very entrepreneurial, and I think that there is a little bit of truth in that, but I think it's also a bit overblown because there's plenty of lawyers who set up their own law firms, like I did, twice as it happens. Yeah, I think go for it. That's what I say.
Great, thank you. And final question for you. What's the one thing that you wish someone had told you before you got started?
I'm facetiously tempted to say the national lottery, the Euro Millions lottery numbers one of the weeks. That would have been very helpful. No. What one thing could somebody have usefully said to me? That's a very good question. I think in retrospect, we probably could have started earlier in terms of thinking about a sales team and things. So we've just, as I said, taken on our first salesperson, but we probably could have done that sort of October, November time last year. So that would probably been quite helpful actually, because it would have taken some of the burden of doing demos and doing sales and speaking at events and things off my shoulders. That said, I don't mind doing that. It's quite fun. But yeah, so maybe we could have moved quicker in that regard. I think as well, the other thing is, and this is something I thought about very carefully, is how you're going to fund whatever you're going to do, and what sort of money do you want behind it? Do you want your own money, angel investors, VC money, those sorts of questions, or maybe some sort of deal with a law firm. So a lot of law firms are looking about making investments into law tech. And I think very carefully about that, because whatever type of money you get will have a big impact upon the incentives and stuff, and therefore the behaviors in the business.
Yeah, amazing advice. Thank you for that. And Philip, I have enjoyed this immensely. Thank you for being generous with everything that you've shared. I love what you're doing, not just for the industry, but for the clients that you're representing. If anybody wants to find out a bit more about Garfield, it's garfield.law, right?
That's it. Oh, yeah, there's another bit of advice. Think about branding. So when we called the company Garfield AI, we thought that would be its name. But then I thought, oh, well, when I incorporate it at Company's House, it'd be really sensible to have the website, because we're a web-based business. So I called it Garfield.law Limited. And so our regulator calls us Garfield.law, but we like to call ourselves Garfield AI. And I think probably that's a bit of confused branding. So think a bit more about branding than I did.
That is also a great piece of advice. Thank you. To anyone that is inspired by this episode, if it made you think differently about what a law firm could be, opportunities for providing legal services in new and innovative ways, please do share this with your networks. If you want to hear a bit more from people like Philip, and these are the sort of conversations that you're interested in hearing more of, subscribe on YouTube, Spotify, or wherever you get your podcasts. For now, Philip, thanks again.
Thank you.
That's Re-Leveraged. Cheers.
Bye-bye.